Hi, I'm Barry Forbes, Associate Executive Director and Staff Counsel of the Wisconsin Association of School Boards. And this video addresses policies relating to the negotiation of the charter school contract. The second step in the charter school application process is the negotiation of the charter school contract. School boards are required by Wisconsin law to enter into a contract with the Charter School Governance Board. The Governance Board must be a legal entity capable of entering into a contract. The Charter School Governance Board must be independent of the school board authorizer. Federal charter school grant requirements also include the requirement that the Charter School Governance Board be a legal entity capable of entering into contracts and independent of the authorizer. Wisconsin law specifies many things that must be addressed in the charter school contract, but as will become clear below, school boards have considerable discretion how the charter school contract is written. NACSA principles and standards direct that the contract clearly articulate the rights and responsibilities of each party and reiterates the requirement that charter school governance boards be an independent legal entity. Wisconsin law at sections 118.40, 2M, 3, and 6 specify various provisions that must be included in any charter school contract. The term of a contract may not exceed 5 years. And school boards, you want to think about this requirement when you pick the starting and end date of the charter school contract, because you do not want the contract to end in the middle of a school year. So you would not authorize a charter school with a contract of, say, October 1, 2019 through September 30, 2024, because you'll end in the middle of a school year. No pupil may be required to attend a charter school, and the contract should make clear that attendance in the charter school is voluntary. Charter schools authorized by Wisconsin school boards may be instrumentality or non-instrumentality charter schools. The employees of instrumentality charter schools are employees of the school district, while those working in non-instrumentality charter schools are employees of the charter school. The contract should specify whether the charter school is an instrumentality or not. This slide describes limitations on where a charter school may be located. The location of the charter school should be addressed in the contract so that the authorizer school board has authority to require that this portion of Wisconsin law be complied with by the Charter School Governance Board. Charter schools authorized by groups of school districts or school districts and a CISA or federally recognized American Indian tribe should be in the territory of one of the schools, the CISA, or the tribe. Virtual charter schools are not subject to these location restrictions. School boards may not contract to convert a private sectarian school to a charter school. School boards may contract with an entity to create more than one charter school. The contract may specify that the charter school will enroll students of only one sex or provide one or more courses that enroll students of only one sex. In such cases, the school board must make similar schools and courses available to students of the opposite sex. Charter school contracts should describe admission requirements. When the number of applications exceeds the capacity of the charter school, Wisconsin law requires that pupils be accepted at random, with a few exceptions as are noted in this slide. Section 118.40 (1)M of the statutes identifies 15 things that must be addressed in employee petitions to create a charter school. Wisconsin law requires that all 15 of those things be addressed in the charter school contract. The 11840 1M contract terms cover many of the critical matters to be addressed in the charter school contract. The name of the person seeking to establish the charter school, the name of the person in charge of the charter school, a description of the educational program, and the methods used to enable pupils to attain educational goals. School boards must pay particular attention to contract language describing how student progress and achievement are measured. The school board holds the charter school accountable for student achievement. Its ability to do so will be based on this part of the contract. More information on the Section 118.401M and other Wisconsin law charter school contract requirements can be found in the Authorizer legal considerations on the Buzz online learning platform. See the narrated PowerPoint presentation, the charter school contract. This slide covers the last of the 118.40(1)M requirements for charter school contract terms. The Department of Public Instruction has created a comprehensive checklist of charter school provisions of contract provisions to be included in the charter school contract. Some provisions are required by law, while others are highly recommended. And that checklist of contract benchmarks can be found both on the Department of Public Instruction website and the Wisconsin Resource Center for Charter Schools website. Some of the highly recommended contract terms relate to Wisconsin and federal law requirements, specifying that the program attendance of the charter school is voluntary, that the charter school not charge tuition, that the charter school not discriminate, and include a non-discrimination clause in the contract. The charter school contract should describe the membership of the charter school governing board. Wisconsin law allows a minority of charter school governance board members to be members or employees of the Authorizer school board. Better practice, though, is to specify that no members of the charter school governance board may be a member or employee of the authorizing school board. School board members or employees serving on a charter school board, governance board, will likely encounter conflicts of interest and issues relating to incompatibility of office and position. Federal laws governing federal charter school program funds also prohibit employees and officers of the authorizing board from being members of the governance board. The charter school contract should specify the powers given to the governance board by the charter contract. This should include enough authority to allow the charter school governance board to act as an autonomous entity. And examples are given in the statute 11840(4)D that you see up on your screen. The Authorizer school board must ensure that the charter school governance board complies with Wisconsin and federal law. The contract should specify that the charter school and its governance board will comply with laws applicable to the charter school, including public and pupil records, the Wisconsin open meeting law, state and federal laws protecting the disabled, and various other Wisconsin and federal employment law requirements. And one thing I think charter school governance boards may not be thinking about as much as they need to is that operating charter schools requires knowledge of how local governments work, and a lot of knowledge that on its face appears to have nothing to do with education. And school boards understand that. They understand the open meeting law and public records law and pupil records law and employment regulations and so on and so forth. And school boards, you need to help the charter school governance boards understand their obligations to comply with those laws. And that starts with writing those requirements into the contract. Other highly recommended contract provisions, including those required for federal charter school program funds, language referencing NACSA principles and standards, and language specific to virtual charter schools. Now we'll switch over to policy consideration. The law allows school boards broad discretion regarding how the contract is negotiated and what provisions are included in the contract. Who will represent the school board in the contract negotiations? Will the school board seek the advice of legal counsel? What happens if the parties fail to reach an agreement? A school board approval of a charter school application is not a guarantee that school board and the charter school governance board will be able to reach an agreement on the contract. Note that the Wisconsin Resource Center Charter Schools has created a model charter school contract for school board authorizers that can be found on their website. Charter schools may be exempted from many state laws and board policies and procedures. Some boards identified by policy, Wisconsin laws and board policies that the charter school may or may not receive an exemption from. It is common for school board policy to specify that all board-approved charter schools will be an instrumentality charter school or may be either an instrumentality or non-instrumentality charter school. As was noted in the definition of charter schools above, charter schools are given autonomy and freedom from some state laws and regulations in exchange for accountability for results. Above are some examples of board policies describing performance standards expected of charter schools. Charter schools at a minimum should be held to the same performance standard that other schools and programs of the district are held. This slide identifies other minimum contract standards that might be written into school board policy. School boards should pay attention to contract language protecting the rights of disabled students. Charter schools and authorizing school boards must comply with the provisions of both Section 504 and the IDEA. At the same time, charter schools are held accountable for student performance and achievement, which creates the inherent risk that a charter school may attempt to avoid disabled students. This slide is from the Madison Metropolitan School District policy. It sets forth the requirements for provisions of services to disabled students by charter schools that must be included in any charter school contract. On this slide, I provided some links to those resources I spoke of earlier in this presentation. The next video will be on charter school monitoring and oversight. You can reach me, Barry Forbes, at BFORBES@WASB.org or at 608-512-1707. All right, we're off.